Good afternoon. This is Professor David Weiss, once again, speaking on global business and global affairs topics of interest using an unfiltered and unbiased approach, and how academics can contribute towards international interest and bring it back even to a more focused local level within the United States. This is all being powered by our platform at the IDR, Institute for Dispute Resolution at New Jersey City University, underneath its flagship business program, Connecting Bridges and Borders. Today our topic is on data protection, a very important and growing field for many around the world, both from the policy side to individual concerns, as well as within the business community, as technology plays a vital role in how we develop out our new ecosystems into the modern era. More than ever, as we are all finding from the pandemic, virtual meetings to virtual classrooms to the way that we're communicating has become exponentially reliant upon technology. But with technology and all those wonderful mediums, there's also another discussion, and that is your personal data. Data is what's driving both blockchain, data drives AI, data drives the ability for this podcast to actually take place today. I am privileged and honored to have a long-term supporter of the IDR's program with me, someone that's been in the field of data protection for many, many years, starting with even in the healthcare industry with HIPAA. Ken Rashbaum is a partner at both Barton LLP, New York City, a full-fledged service law firm. He is also an adjunct professor who has taught at Seton Law School. He is also teaching at Fordham. He has recently become an advisor to PACE, and we'll talk a little bit about his work on that project, and is now working and collaborating with the IDR under the Connecting Bridges and Borders program as well on the launch of its data protection certificate program. Ken, welcome to the show today. How are you?
Good, David. Thank you. Thank you for inviting me.
So I would like to start out by giving the audience a little bit of understanding about your background and your passion and interest in why you really dived into data protection generally. And then we'll sort of walk through some of the salient issues that my listeners, I think, will be very interested in hearing from you on.
Sure, thank you. I head the Privacy, Cybersecurity, and Technology Transactions Practice Group at my firm, which, as you said, is a full-service business firm with an emphasis on any business that is related to technology. We are a New York firm with an office also in Nashville, Tennessee, but we have a significant percentage of our client base that is from outside the U.S., mostly Europe, but increasingly Asia and South America. I moved into this space for many years as being a healthcare attorney when HIPAA began to appear on the horizon in the early 2000s. And I recognized the opportunity, learned everything I could about the privacy and security rules of HIPAA. HIPAA still to this day being the only national data protection law we have in this country, except for some of the SEC regulations, but they only apply to public companies. And from there, after my team at my prior law firm, Sedgwick, started a practice group that went nationwide with HIPAA teams in many different states for many different academic and smaller hospital systems. The firm had clients with global presence who had data protection issues, and it came to my team to learn that, and that's how I moved into the international space. And right now my practice is, I would say, about equally split between international work, work for US companies, and work for life sciences companies, software developers in the healthcare space, remote access to implantable devices, apps on your phone that you can use to keep track of your health information, contact your physician. I do their contract work. I do their counseling on the wide variety of state and country regulations in these areas, and I represent them when they have data breaches.
That's fascinating information, especially on the practice side. What about we focus on the practice side, and then we'll pick back up on the other part of what you're doing, which I'll refer to as the educational perspective of this, or tooling. Give us an understanding, a primer, if you will, for our Zoom audience and podcast program time frame level that we have. Where this began in terms of understanding why the United States now is focusing on data protection, but maybe first we can have a conversation about that primer of what took place in Europe that really began this new level of both policy and interest in how data is both mined, processed, and controlled.
The Europeans have had a better sense of this than the United States for many years. The European Union has actually been the leader in this space, going back to 1995 when it passed the privacy directives, which were not law, but were a base level, and every country was required to implement them to its own extent. A lot of our privacy law is based on the European Union privacy directives, including HIPAA. Many people don't know that, but for those of us who work in both spaces and we look at the time difference, it's very clear that we drew a lot of principles from European law. The General Data Protection Regulation, which is the law now, came into effect in May of 2018. And contrary to the directives, which were to be implemented by each country as it saw fit, the GDPR, subject to a few exceptions, is law in all 27 member states. And some of the other states that are not EU members have adopted it in a similar fashion. In fact, the UK, in preparing for Brexit, passed the Data Protection Act of 2018 to, in effect, implement GDPR after the UK broke away from the European Union. It's a big deal for American companies because it has what's called extraterritorial jurisdiction. It applies to any entity anywhere in the world that is selling goods to European Union residents, marketing to European residents, or tracking them over the internet. If your company's dropping a cookie on whoever goes to your website to track them over the internet, and that person comes from Lithuania, you are now covered under the GDPR. And the penalties are huge. The maximum penalty is 4% of global turnover. That means global revenue, not profit, revenue, or 20 million euros, whichever is greater. And that's for an intentional or reckless violation. If it's merely a negligent violation, maximum penalty is half that. Now that sounds like an awful lot, and very few penalties have been imposed at that level. But some countries, like the Netherlands and Denmark, and recently Germany, have implemented a schedule of lesser fines. Why? Because they want to show the smaller and mid-sized companies you're not exempt. You can't fly under the radar. We are looking at you too because we have a higher purpose here. In Europe, privacy is a fundamental right. It is enshrined in the Constitution of many countries, and this is following on their experience after World War II in in Europe generally, and specifically Eastern Europe after the Soviet Union collapsed. So they've now swung the opposite way from the United States and are much more protective of personal privacy than the U.S. is. But the U.S., after Equifax and some of the other major breaches here, have actually, some of the senators and representatives have actually started to say, wow, maybe Europe had a good idea after all, and we should do something very similar to that. And we're seeing that in some of the bills coming up in the states. We'll see when we talk about New Jersey's bills, we'll get into that in a little more detail.
Yeah, and you raised two parts to which we'll use as the closeout to the GDPR, sort of leave it out there in the ethos for our listeners to digest, because they could themselves be discussions on another podcast. One is this idea of the fundamental right, that you raise. And there are, what I've read, there seems to be embedded into the GDPR, there is some reference to fundamental right, but there are two camps of scholars who are arguing whether or not that is a expressed fundamental right that was purposely designed into the GDPR framework, or if it's being used as a way to argue that it is a fundamental right within the framework of GDPR. Which part of that camp do you fall on, or have you not yet made a decision?
Oh, that's pretty clear. It's a fundamental right in Europe, period. Privacy is a fundamental right. If you look at the definition of what is the sort of character of data that's protected, it's called personal data, and it's pretty much a one-line definition. Any data that can be linked to a natural person. And it's deliberately broad to do two things. One is to embed that fundamental right, that if it's your data, it's your rights to it. As you pointed out earlier, it is you, it's your identifier, it's what's about you. You have the right to control it. All right. And the second part of it is it's deliberately broad to allow for changes in the technology. AI, for example, different modes of communication. We were having this conversation 6 or 7 years ago. We would probably not be talking much about SMS or text messages. Now that's fundamental.
And if we use that as a transitional period to the United States, which seems to, at least in modern times, look at a more pragmatic business approach to how certain international policy considerations are adopted or brought into the United States for consideration. One of the two elements is this business friendly? And the second element is how do you create mechanisms that would really give teeth to the consumer or to the constituents that may want to apply a legislative model law through an adoption of a model law, if one should exist, for example, through like the Uniform Law Commission, or if a state creates one from the get-go, like California did, or as you raised, New Jersey has some circulating drafts currently down in Trenton. How do you see the US sort of perspective as we see the landscape today? And maybe you can use one of these states, maybe New Jersey, for example, as a case study to sort of explain those questions I'm asking of you.
All right, you've got a lot of concepts and principles embedded in those questions, so let's see if we can unpack them one at a time. First of all, let's debunk a myth. There is no such conflict between the business community and the consumer community on data protection. Data protection is the blending of privacy and cybersecurity. They used to be considered in silos, but no more, because you need security to implement privacy. The two things are related. New York recently had in effect the SHIELD Act, which has privacy provisions and cybersecurity requirements like encryption. Right? They were put together. A number of other states have done the same thing. Massachusetts was the first one to do it back in 2010. There is no conflict between the interests of business and the consumer community on data protection because data protection is good for business. It attracts business. Why? Because in 2020, customers are insisting that the company be a good steward of their personal data, that it be transparent about how it's being used, with whom it's being shared, and how it's being taken care of. And there are two examples of that. These are empirical examples. One is Accenture did a study about a year and a half ago that found that companies that are meeting GDPR requirements, just using that as a standard, have shorter sales cycles. To put that in layman's English, they get money in the door faster. They get the business faster because nobody wants to work with a company that's not going to take good care of the data. And in my practice, most of my GDPR clients, I take that back, all of my GDPR clients came to me not because they were afraid of being sued or getting these big fines. It was because they had customers or business partners dangling 7- and 8-figure contracts in front of them on condition that they meet security and privacy standards in the GDPR. And why is that? Because these business partners in turn had their own customers who were insistent that they take care of the data. So it goes down the chain. And that's the positive way to look at it. The negative way to look at it is that if you don't do it right, you will lose business. Okay. I work with a number of law firms who get audited by their clients for security safeguards. Some of that is because the law requires it. New York's Part 500 Department of Financial Services regulations require that whoever you're going to work with, who's going to have access to your protected data, must have these safeguards built into the contract as representations and warranties. GDPR does too. Curiously, California does not. For what we hear about the California Privacy Act, it doesn't have that kind of a protection. And we saw it recently with the very platform we're working on now, Zoom. Zoom had a contract with the New York City Board of Education. Well, it was called the Board of Education. Now it's called the Department of Education. Over 1 million students, 1,800 schools. And when the New York Attorney General began investigating Zoom because of security flaws.
What they call the Zoom bombs.
The Zoom bombs, and worse. Yeah. They found that some of the flaws were actually allowing people to come in and take control of people's computers. It was that bad. And Attorney General Letitia James sent an investigation letter to Zoom. And shortly after that, the New York City Board of Education terminated the contract with Zoom and banned Zoom from use for online teaching.
Well, and that brings up the two other elements of that very elongated question I asked you that was filled with a box of, as you said, or a basket of different interesting topics. So the two that sort of were not answered, which we can maybe use as a separate part of that segment, is using New Jersey as sort of an example. The ability that if these platforms are then going to be reliant upon some framework of data privacy and protection laws, whether they become state by state, whether it's a model law adopted by you, like, for example, the Uniform Law Commission, and at some point, some federal evolution into this, where is the consumer's rights, or where should the consumer's rights be in this? You're hearing two arguments sort of set. One is from one side of the camp, I'll be clear, business-related camps, is that you don't necessarily need to see more than the burden of enforcement being laid at the table of the attorney generals, or some functionality within that system or framework, which then leads to resource allocation from a state that have to enforce the rules. The other side of the camp says that there should be a separate civil part to this beyond maybe just a statutory part that the attorney generals would deal with that would allow for a privacy right of action. How has New Jersey sort of looked at this, and what are some of the unique, innovative approaches it's taken to try to assuage these concerns from the business camp that does not want to see privacy right of action inside these data protection initiatives taking place throughout the United States?
Well, the private right of action, just again for the benefit of the audience, is the right of an individual to sue for a violation. And when you and I started working on the first Data Protection Act in New Jersey in 2018, that was the only bill that was there at the moment, and we had a private right of action built in, but with a unique feature that is seen nowhere else in the country, which is a 30-day notice to cure. And during that period, which means during that period of time, you cannot bring a lawsuit because the state will offer mediation during that period of time. So the number of lawsuits will go down. And when we were talking to business groups about this, the business groups were very concerned about the private right of action. And we said, but wait a minute, hold on. There aren't going to be that many lawsuits because there's a right to mediate. Mediation is going to get rid of a significant portion of those lawsuits. We don't have data on how many lawsuits would be resolved in mediation, but since it's less expensive and less time consuming, there would obviously be a great deal. The only other bill that came up when you and I were talking about this back then was a bill sponsored by Assemblyman Raj Mukherjee, and his bill had no private right of action, just like California does, except that California has a limited private right of action for data breaches, but not for any other violation of the statute. Interestingly enough, the pendulum has swung the other way. Perhaps in the light of all of the major data breaches that have happened since 2018, the two other bills that are pending now, there are three at the moment, the one you and I worked on that was originally sponsored by Valerie Veneri Huddle from Bergen County was sponsored in the Senate by Thomas Kane Jr., and he has now reintroduced it in the Senate. It is the bill that we mentioned. The mediation aspect of it is in amendments that were printed up later on by the Office of Legislative Services. But curiously, the other two bills that are pending not only have a private right of action, they have a provision that any violation of the statute, no matter how material, is to be considered an unlawful business practice under the state's consumer fraud law. That means that an individual can bring a lawsuit and can get triple damages,
Right.
3 times the amount of actual harm they suffered, and have his or her attorney's fees paid.
Right.
Far greater than the private right of action you and I wrote into Assemblywoman Huddle's bill, and that we got so much objection to.
That's an interesting observation, and I think many folks that will listen to this particular podcast who are interested in the specifics of the private right of action and mechanisms to utilize enforcement could possibly use these different scenarios playing out in the way the bills are being approached using private right of action, but through different frameworks going forward within their own states or under a model law framework as well. So I appreciate taking the time on this. I want to move a little bit to the educational element of this for a second and leave with the idea that where do you see from the business side as a sort of a closing statement, how are they going to address the liability issues? I sort of will utilize the concept of real estate. If I'm going to sell a piece of real estate with a roof that needs repair, the buyer is going to take into consideration the element of what that cost is, and then factor that into what their offer price is. Right. How are we going to address that liability if a company has not provided or implemented appropriate data protection mechanisms with or without a jurisdiction that is requiring them to do so? And the second part of that is, should there be a financial accounting statement board or the equivalent on the international level recognition of this so that accountants can actually start to be trained and comply when it comes to GAAP or audits, so that both the transactional and corporate world, as well as within enforcement world, there's a valuation system that everyone can actually index to?
Well, let me take that last part first because it's top of mind, because I recently wrote an article about this very thing, about in the healthcare field. I co-authored it with a physician and an accountant. This is not a joke. A lawyer, an accountant, a physician walk into a bar. But you need all three disciplines to value a medical practice, because almost all medical practices now have medical records that are electronic. And electronic medical records will tell you the value of the practice. In the paper world, the same thing. Doctor's practice was sold, or multiple doctor's practices were sold. There had to be an audit of the paper records. So now there's an audit of the electronic records, but with an additional aspect, which is compliance. Not only Office of Attorney General compliance for potential fraud and abuse, for insurance payments or Medicare or Medicaid payments, but for security. How secure are these records? Because if they're not secure, the value of the practice is going to go down. And this is not new to medicine. Look at what happened with Marriott and the breach of its Starwood facility. The United Kingdom's Data Supervisory Authority has proposed a fine of 99 million euros. All right. Against Marriott for failing to do cybersecurity due diligence in its acquisition of Starwood. And a large part of my practice now is privacy and cybersecurity due diligence on the part of acquirers. If a company is looking to buy another company, or a private equity fund is looking to acquire an interest in another company, we do a lot of private equity work, and they will ask us to draft the due diligence questions, and I'm part of the team. I draft the cybersecurity and privacy, the data protection questions, because if the company is not compliant, they're not a good risk. Who wants to buy a company that's a regulatory risk? So either the deal goes south, which I don't see very often. I've only seen that once out of dozens of deals. But usually either the price goes down or money is kept in reserve for a certain period of time against the possibility of fines, penalties, or lawsuits.
And this is a great way to sort of end the business aspect of this, because there's a lot of, I think, further conversations that need to take place for businesses to sort of not just ignore the inevitable, but also embrace all the different aspects of both the value, the regulatory, and also the transactional side of things. If we phase into the educational side, I know I mentioned in the beginning that you're teaching at Seton Hall, you've been teaching at Fordham, you've now taken on some posts at Pace, you're working and been engaged with the IDR for a number of years, and I want to thank you for your generous support both here and internationally in the work you've done coming to our programs on connecting bridges and borders through Budapest and Hungary. What are some of the things that you see as we wrap up our program today that we can leave our educational system with that are important beyond the notion that this is just something to be put in a box within the context of law or inside some computer science department?
This covers, data protection covers every aspect of business. 99% of all business correspondence is digital. Less than 0.1% is ever printed. It's all digital now. The business lives online. All right, so this is the lifeblood of the business. The Economist magazine years ago famously called data the new oil. So every business school, let alone law schools, should be having a number of courses in the value of data and the value of securing the data. Both those things are critical, and that's what I try to bring to my Fordham Law School class. And this is, I think, where the adjunct faculty, like myself, lend real value, because we're dealing with the real world aspects of this on a day-to-day basis. I'm on the advisory board now for the Pace University Seidenberg School of Computer Science. And the parts I'm probably going to be involved in are going to be GDPR and privacy and vendor management. How do you make sure that your business partners are taking good care of the data you entrust to them? How do you put this in agreements with them? What are the controls? How do you audit their agreements in a way that enhances the business relationship and doesn't add additional tensions to it? All this needs to be taught at the graduate school, business school, computer science school level, because the textbooks don't give that to you. the textbooks are outmoded anyway by the time they're published in this space, because this moves, as we used to say in Star Trek, at warp speed.
And I would say this, Ken, that given the situation we're all in with this pandemic, I think all textbooks starting about 3 months ago have now just gone out.
Yeah,
Wow.
absolutely. Absolutely. I've been having a number of discussions, both in class and with some of our clients, about what's going to happen to privacy when you start doing contact tracking for COVID-19. Once privacy rights are lost, albeit for a purpose like public health, it's almost impossible to get them back. We saw that after 9/11.
And I think that's a really great way to end the show, is where we began it, which is it's about data protection. It's about data policy. But at the end of the day, it's really about privacy and the fundamental rights of what you believe in, which is that it is a fundamental right. And whether or not our audience, let it sit with them and think about it themselves. Is it important enough that their personal data in today's world should be considered a fundamental right? And if it is a fundamental right, and it is important enough that to them, that is something that is inherent as breathing air, then how should policy within their home countries reflect the level of that priority? Ken, I want to thank you so much for the opportunity to speak with you and have my audience get to hear about your expertise, the work that you're doing, the shared collaboration you do with the IDR on our mutual interest of promoting international business, as well as the policy we work on together on data protection here in our state of New Jersey.